My name is Marumo Mudiba, the Senior Manager for Corporate Education and Voluntary Compliance. Allow me, on behalf of the Commissioner of CIPC, Advocate Roddy Fowler, and the entire organization, to convey humble greetings and welcome you to this valuable, very important concept of business rescue. CIPC mandate emanate from the Companies Act 2008. And the organization is a self-sustainable agency operating under the umbrella of the DTIC. And CIPC is very much focused in ensuring that members of close corporations as well as directors are capacitated to understand the concept of business rescue. Recently, our senior manager, Mr. Buyani Nkosha, engaged with the business rescue practitioners, and it transpired in terms of trying to understand what could be the challenges that they experience in managing businesses that are in the business rescue. And it transpired that many of the SMMEs specifically do not actually even understand the concept of business rescue and what is expected of them. And as well as the other point that came across was the fact that companies and close corporations wait until it is too late to resolve to place the companies under voluntary business rescue. Hence, this concept being one of those important ones, as I highlighted, that it is a ministerial priority. Hence, CIPC, through the senior manager, Mr. Buyani Nkosha, have developed an online business rescue uh, uh, platform to try and capacitate freely so the members of those corporations as well as directors of companies in terms of capacitating them through this online training to understand this concept. So there are lots of things happening as well as other educational activities that will be coming through to try and capacitate our citizens. Hence, today's webinar will very much so put more focus in terms of ensuring that companies, particularly SMMEs, are capacitated to understand and showcase the importance of business rescue. Having said that, I would like to also uh, highlight to the participants of today's important webinar that the presentation will be available. It's available actually even now to download under the handout tab, and also to highlight that the recording of today's webinar will be sent out through email after this webinar. And members are also, or participants, advised to type their questions under the chat tab. And we are graced by the presence of the senior manager, Brian Nkosha, as well as a capable colleague, Ms. Nkuna, whom will also respond should there be any other clarity seeking questions after this webinar. I would therefore uh, like, after this introduction, hand you over and introduce Ms. Tsakani Nkuna, whom will do the presentation and take us through the presentation. And again, please type your questions under the chat tab, whom which we will respond to. Thank you. Over to you, Tsakani.
All right, thank you so much. And good morning once again to all our participants for today's webinar. So, for today's presentation, we're going to be focusing on four key issues. The first one being the importance of business rescue as a viable option as opposed to the liquidation of companies that are financially distressed. The second one will be the role of directors and members in business rescue. The third one will be key educational areas for directors and members. We will also focus on the moratorium that is afforded through business rescue. And the last one, which is the fourth one, will be on how to best place a company into business rescue. So over the years, the Commission has come to an observation that there is a misconception and perhaps also stigma surrounding the roles of directors in business rescue, or rather, let me say, companies that have entered into business rescue. So in terms of our objective, premised in the Companies Act, specifically in Section 186 of the Companies Act, which directs us that we are to promote education and awareness of company and intellectual laws. We took the decision to host this a webinar to bring into awareness and educate directors and members on business rescue and how they can best navigate the complex legal landscape in the rehabilitation of a financially distressed company. But also, in addition to that, the current initiatives that the CIPC is currently undertaking, and one of them is compiling a training that will specifically target members of CCs and also directors, and it's going to be based, or it's going to focus on the business rescue regime, how to actually lodge for business rescue, the advantages of business rescue, the role of directors, and members and also directors are encouraged to sign up for the training as such will be communicated. But also to just sort of give a historical background on the business rescue legal phenomenon, you would know that it came in as a policy reform, and which was incepted to remedy the shortcomings of the former corporate rescue procedure, which was the judicial management corporate rescue procedure. So with the former judicial management rescue procedure, it was more focused on creditors and ensuring that they have better return. The focus was on creditors, but with the inception of the business rescue regime, it focuses more on balancing the interests of both the debtor and the creditor. And this is to assist in the economic growth and the preservation of jobs in our country. So one may inquire on why is it important that companies should actually enter into business rescue. We'll have to take note of how our economy is currently performing. So in terms of the stats that were released by Stats SA, which is the Q2 of 2025, it has indicated a growth of 0.8% in our GDP, but however, our economy is slowly growing. So the shift in policy is vital in assessing that there's economic growth where there are failures. And there's also a misconception with regards to failures of a company. I think majority of people think that failures of a company that may lead a company to entering into business rescue are literally influenced maybe by reckless trading. But however, the various factors that actually influence that, which can be both internal or external. So the business rescue policy on its own will assist those failures by ensuring that the companies or CCs are given the breathing space where they have to restructure an overview of their processes. So for example, some of the issues that can actually affect the functioning of a company are maybe, for example, failed business model, unavailability of funding, and abandoned contracts. So with entering into business rescue, you'll be given that opportunity or that breathing space to be able to restructure your affairs. If there's a need to adapt to current changes, adapt to those current changes, which may be legislative changes or compliance-related changes. And if there's a need for such a company to expand or just decrease its product offering, such will be done through the business rescue processes. So it is quite very important that directors are brought into awareness with regards to this and are brought into awareness of the legal framework, that there is a legal framework that was to assist in the rehabilitation of financially distressed companies and preventing the immediate liquidations of those companies. So the whole process on its own, I think it's important to emphasize on this one, is that business rescue is not intended to be a long-term process, but rather a temporary one, to give the companies again the moment or the briefing, the space, or the what we call the briefing space, to actually oversee its processes. If there are any changes that need to be done in terms of the strategy of such a company, then this is the moment that we have to do such in order to ensure that they go back to operating on a solvent basis and protect the company's going concern value, but most importantly, in terms of our economy, contributing positively into stabilizing our economy and also preserving the jobs of all South Africans in our country. So further, I'll enlighten you more on the importance of business rescue. Number one is the prevention of liquidation. So before the act, as I had highlighted, that there were various mechanisms that were afforded through the judicial management and also with the liquidations of companies. So before the act, financially distressed companies often faced liquidation, which meant that business ceased to exist. So with business rescue, it offers an alternative to that, to say, let us keep the company operating, let us keep the trading of the company going on so that we can positively impact the economy without not closing off our operations and in turn losing jobs. The second one also is it provides a temporary moratorium. So this is a stay on the legal and enforcement proceedings against the company, which are put into place to give the business breathing room to restructure without immediate creditor pressure. So you can't, if a company is in business rescue, you can't really take on legal action against it unless you have the leave of the court to do so. So this is one of the benefits of actually entering into business rescue, because it gives you that opportunity to focus on the restructuring and re-strategizing of your company affairs to ensure that you operate again on a solvent basis. Number three, the facilitation of restructuring. The business rescue practitioner who will be appointed can restructure the company's affairs, including its business model. I'd already explained this, whether they can just decrease the product offering of such a company or decrease the product offering of a company, depending on the complexities of such a company. This restructuring can also focus on the assets and the agreements of such a company. But the main issue here, or the main aim here, is to actually ensure that the companies return or are restored back to operating on a solvent basis. So number two, it balances the stakeholders' interest. And as I explained before in my introduction, that is one of the reasons behind the reform of the policy, because with the judicial management system, it was more focused on the creditor. So, but with the inception of the business rescue regime, the process is designed to balance the rights of various stakeholders, such as creditors, employees, and shareholders, to reach a business rescue plan that is acceptable to all parties and where all parties' interests are actually balanced. I've already spoken on the preservations of jobs and economic value. It's important that we have more companies participating on the economy. The more companies we have, the better in terms of stabilizing our economy and ensuring sustainable economic growth. The last one will be that the offering of a better outcome for creditors. So with the introduction of business rescue, or rather utilizing business rescue, it offers a better outcome for the creditors than would have been in the immediate liquidation of such a companies, by allowing maybe a prolonged period for the operations of the company to continue. So I'm going to go to the roles of directors, and as I had highlighted that there's quite some stigma around this, or misconceptions, that when a company is entered into business rescue, the directors no longer have any job to do. Everything falls within the hands of the practitioner. But however, we are here to clarify those misconceptions. So we'll deem that companies that are in business rescue are deemed to be experiencing temporary setbacks, and that is why there's no part in the act where it says that there must be a reasonable prospect that such a company will be resuscitated to come back and operate on a solvent basis. So therefore, members and also directors are encouraged not to abandon their duties and vacate their offices in the case whereby a company is entered into business rescue. The second one is that in respect to appointment of business rescue practitioners, it's quite important that directors and business rescue practitioners actually have a good relationship. So in the appointment of those business rescue practitioners, I would really like to encourage directors and members to say, conduct due diligence processes, and this can be done through interviews. You interview the prospective practitioner. You could also require referrals as to the work they have done, and also look at the skills, right? I think it's quite important. The issue of skills is quite important. Will they be able to sort of cater to the needs of such a company? Do they have the necessary skills to actually cater to the needs of such a company and the complexities of their company that have led to the company being in business rescue? So that is important. And we highly encourage that that must be done by the directors and members, because the commission cannot do it on their behalf. It's their duty. So they should actually, you're encouraged to actually conduct those due diligence processes. So as I had highlighted, during the phase of business rescue, it is expected that directors and members and also business rescue practitioners should have quite good relations in terms of being able to assist one another and cooperate with one another in order to provide all necessary information. If there are any documentations that need to be handed over to practitioners, those can be handed over to practitioners. Now, another issue that we would like to highlight is it doesn't mean that when a company has entered into business rescue, now the directors of such a company are now incapacitated, but they are still very much capacitated, and they must operate within the limits that have been set by the BRP, retaining some management control subject to the BRP's directions as per the Act. So the pre-rescue duties includes advising stakeholders of financial distress if a rescue is not filed, with failure to cooperate, potentially leading to personal liability or disqualification. Another important fact we'd like to highlight is that from January to I think October, over 50% of entities that have returned into business have been susceptible to the deregistration process due to non-compliance with the filing of annual returns. So that is why it's important that we need to emphasize on the issue of continuing with your compliance duties. So it doesn't mean that if a company has entered into business rescue, there's a suspension of the compliance duties or the compliance requirements in terms of the Companies Act. You are still required to file your annual returns, and for companies that are required to file their audited financial statements, they're still required to do so. So entering into business rescue does not suspend those compliance requirements. They still need to be adhered to and complied to. So for key educational areas for directors, I think number one is to understand what exactly financial distress is and the early warning signs. So directors must be able to recognize the signs of financial distress as defined by the Act. I think, for example, if you are operating on a break-even point for long periods of time, that on its own can signal that there's a need to restructure, there's a need to monitor the operations of the business. So directors are actually encouraged to be able to capacitate themselves, to be able to recognize signs of financial distress, which will include situations where the company is unlikely to pay debts within 6 months, or is likely to be insolvent within the upcoming 6 months. So we look at the factual balance sheet insolvency. So early recognition, or what we call early dictation, is important because it maximizes the chances of a successful rescue. Number two is the mechanics on commencing business rescue. So directors need to be aware of how business rescue can be initiated. And it can be initiated through a voluntary board resolution, which is the Section 129 process. We'll discuss it further, or via a court application that can be made through the higher courts, and that can be made by an affected party, and an affected party would include a creditor or an employee. So it's important that strict procedural requirements and deadlines for the filing of notices are actually complied to, and those can be found under Section 129, especially with regards to commencing business rescue through the resolution, which is Section 129 resolution. Now we go to the role and powers of the business rescue practitioner. So once the BRP has been appointed to take control of the company's management, can delegate tasks or even remove existing management. The BRP investigates the company to assess the prospects of the rescue. Now, also, it's important again to also note that directors retain their duties and liabilities as directors as promulgated in the Act. So it doesn't mean that when a company has entered into business risk and now there's an appointed overseer of the proceedings or an overseer of the company, that the duties of the director are now eliminated. No, it doesn't mean so. Directors and members should understand that their duties are not entirely suspended during business rescue proceedings. However, those duties will be done under the discretion of the authority of the BRP. So they still maintain their fiduciary duties, they have to cooperate with the BRP and can remain personally liable for actions like reckless trading. So understanding the distinction between governance and management functions is important as some powers stay with the board. Number two is on the removal of directors. So I think this is one important one. In terms of Section 137, subsection 5, it prescribes that at any time during the business rescue proceedings, the appointed BRP may apply to court for an order to remove a director from office on the grounds listed from Section 137, subsection 5A to B. Now, it's important to highlight this one. The board of directors cannot be removed from office without an order of court by the court, which was applied for. So that is important. And we need to sort of explain the distinction between the board of directors and also the management. So the management will refer to people that deal with the day-to-day operations of the company. But with regards to the board of directors, a court order has to be obtained before the directors may be removed from office. But also, however, with the management, the BRP has been provided with the discretion to actually remove them from office without a court order. Okay, so I'm going to explain a little more on the process of placing a company into business rescue. As I had outlined that there are two prescribed processes. Number one is the Section 129 process, and this is through a board resolution. So this is whereby the board of directors will come together and say, well, there's been an observation that the company is not doing quite well and would like to place it under voluntary business rescue. And then with such, Section 129, subsection 3 and 4 actually outlines the administrative requirements in that regard that need to be complied with in bringing an application for proceedings under Section 129, and such will need to be filed with the Commission. So such resolution may not be taken if a company is in liquidation or there is a liquidation application. You would rather have to opt for the Section 131 procedure. So with the Section 131 procedure, an affected party may apply to court at any time for an order of a court to place the company under supervision. So affected parties also include employees. That I think needs to be highlighted. So if employees' salaries and bonuses have not been paid, they have a right to approach the court and lodge an application to place such a company into business rescue, as they are classified as creditors and affected parties in business rescue proceedings. So with my conclusion, I think it's quite imperative that we get to educate directors and members of the viable option in utilizing business rescue. And this in turn is also to keep the operations of the company going forward, also the preservation of jobs, and also with contributing positively and directly into sustaining economic growth. So it's critical for the effective and a successful application of the business rescue mechanism. Number two, would like to emphasize the need to always monitor the affairs of your business, because with the monitoring, you'll be able to detect whether or not there's a need to restructure the affairs of your company, which can be instituted through the business rescue processes. So early detection is quite very important. Number two is the clear understanding of the roles and duties of directors, and also their limitations, therefore, to ensure compliance with the Act and avoid personal liability, and ultimately maximize the chances of rescuing a financially distressed company. So comprehensive education is quite very important. And as the CRPC, we are bringing that into awareness. Also, I'd highlighted that the Commission will be releasing training that is specifically directed for directors and members. So comprehensive education is important. This is also to transform business rescue from being poorly understood so last resort measure into a strategy that can generally promote the efficient rescue and recovery of viable businesses. So also by balancing the interests of all stakeholders as intended by the Companies Act. That is the end of my presentation. Thank you.
Thank you, Ms. Sakaninkuna, for a very informative presentation, and I have no doubt that our participants have really received value from your presentation, as you have highlighted the importance of business rescue, and as well as touching on how this process can assist the South African economy in ensuring that we keep more companies within the economic mainstream. I therefore request you to perhaps go through the charts that our participants could have raised questions, which you can quickly respond to. Thank you. Over to you.
There's a question from Mr. Deborah Christopher Maudo, sorry. He says, please clarify, how does the directors remain liable if the BRP assumes full control of the company during the business rescue proceedings? Mr. Nkosha will take that one.
Thank you so much, Sagani, and good morning to the participants. I tried to respond in writing. So I think just to emphasize what Sagani was saying is that when a company is in business rescue, therefore it does not mean that by placing a company in business rescue, the directors are absolved from their responsibilities. And if also there are certain actions that they have taken that are against the laws and that have rendered the company to be in financial distress, such may come up as the investigation will be done by the BRP. And therefore, there would be consequences. The BRP will be responsible for the BRP, for the business rescue proceedings. And therefore, taking over, it does not mean that the BRP will take over, including the liabilities of the board. The board will still have to answer. So that's where the distinction is. The other question is, what are the requirements for one to be a business rescue practitioner? I think we will indulge this question because we have time, but it's not what the presentation was all about. So to be a business rescue practitioner, Section 138 provides what are the qualifications for one to be appointed as a business rescue practitioner. And one, it says that person must be a member of a professional body in good standing, and the professional body must be accredited by CIPC to have its members as to serve as BRPs. Number two, this person must be licensed with CIPC as a business rescue practitioner. Number three, this person must not be disqualified to serve as a director of the company. And when this person is to be appointed, then that person must not have any relations with the company that is going to be a business rescue so that there is an element of impartiality when this person does its work. So those are the requirements in a nutshell. And then, can a company choose the BRP? It is the company that appoints BRP. It is not CPC. So hence the presentation was advising the directors as well as members, when they are to appoint a BRP, they must do due diligence, and they must make it a point that the person has the requisite skills that will assist the company to be rescued. So I would use an analogy of a person who is sick, and the parents will choose a doctor, they will choose a specialist, they will do some kind of an analysis in terms of this person, the cases that he has done, and all those things to save the life of this child. So business rescue, that's what it's all about. So yes, a company must choose. It is only in the event of Section 131 where an affected party may nominate a business rescue practitioner when they apply for the company to be placed in business rescue. Mabel Ndlovu then says, I'm new in the business industry. I want to know, how do we register for business rescue? Thanks. So Tsakane did mention the process of registering for business rescue, but one of the key features for a company to be placed in business rescue, one is that the company must be in financial distress. And then the second one is that then there must be a reasonable prospects for a company. There must be prospects for the company to be rescued. So meaning that the business rescue is not for the terminally ill entities. If the entity it is not going to survive, the business rescue is not meant for that. The business rescue is meant for the companies that there are prospects, maybe there's some problems with the contract, or maybe there's a problem with funding, but the company has a potential, and therefore the business rescue is to give the company that breathing space to come back and be able to stand on its 2 feet, as it were. And then reasonable prospects is defined in the Act. Do you know? It's not defined. Do you know why it is not defined and what will be defined? Yeah. So reasonable prospects will be subjective. Hence, it is not defined. But the reasonable prospects, it is something that the company would believe that, for an example, if we get a funding, the company will be rescued. And therefore, there are prospects because of the business that you are in has potential. We have all the resources that we need, but the challenge, maybe it is for an example, some of the challenges that we had during COVID is that the businesses had to operate at the scale where it was not totally opened, and it was difficult to move around, and some to get stock, it was difficult, it was expensive, and some of the companies probably they went to business rescue, and there were prospects if things changes and all those things. So that is why the Act does not define the reasonable prospects, because the prospects will depend on each case, depending on what led the company to be in business rescue. What are their fees and billing structure? And I would assume the fees are the fees of the practitioners that are being asked here. So the fees of the practitioners are regulated in the Companies Act, and also the BRPs probably will then enter into negotiations with the company and negotiate maybe the success fees and whatever. So it is the arrangement between the companies. But in terms of the standard fees, the Act provides in Regulations 128 the tariff fees for the practitioners, depending in terms of their classification. So if you are to look in terms of the junior practitioners, then they will charge up to a maximum of 1,250 per hour. And then we'll have, that is for small enterprises, and then for medium it's 1,500 and then per hour maximum, and then for big companies, large companies will be 2,000 per hour. So those fees are regulated. Okay, the other one is just the statement. The person is just telling us that it's still available across the country. And then does APC offer CPD certificates for this webinar? Yeah, so we are in the process. I think the colleagues, they have mentioned that. Not for this webinar, we're not issuing the CPDs for this webinar, but we are in the process of coming up with trainings that will be CPD linked. We are in engagement with the National School of Government, and as soon as we complete that, we'll then allocate the CPDs accordingly. Initially, we had a challenge with the platform, so we have sorted now the platform. And the previous tool that we were using was not even recording the attendees. So at least this one is able to record that, and then we'll then manage the process so that we are able to allocate CPTs. But for this one, there are no CPTs. Does the director still have compliance duty when the BRP was brought by a court via the court order? Yeah. So when the BRP is appointed by the court, it is appointed by the court so that there is no vacuum. So what happens is that the affected party will place the company in business rescue, and they will nominate a person, which that nomination then will have to be ratified the meeting of creditors. Now, what happens is that it does not mean that the duties of the practitioner changes. Whether the practitioner is appointed using Section 129 or Section 131, the practitioner is an officer of the court throughout. But again, the duties, they remain the same. The director, they are responsible for their day-to-day running of the business. And the director, they must continue to make the decisions, but it must be ratified by the business rescue practitioner so that they do not make decisions that are going to compromise the business rescue plan. So that is why it has to be ratified. But it does not mean that they must sit back and wait for this BRP, who is viewed as a messiah. They must be working together to ensure that the company comes back to life. What must the BRP do in an event where the company has a pending case against one of the debtors of the company, and the matter is in court, and this is one of the causes of the financial distress, but there is no movement in the case, and the creditors are constantly wanting feedback from the BRP. At the moment, there are minimal funds and business can't operate optimally. Yeah. So case matters. If they're before the courts, it therefore means that the BRP and the creditors, because the creditors, they would know what is happening, because the minute the matters are taken to court, the BRP has a responsibility to notify everyone involved. And therefore, they would know that they will have to then wait for the matter to be ventilated at the court and the decision is arrived at. And the court will make then the pronouncement. And that's what the business rescue practitioner needs to do, is to keep the people abreast, communicate and give them heads up and where the company is at in terms of any litigation that is taking place. Is 25 days enough to determine reasonable prospects when considering that the plan ought to be published within this period? 25 days may be enough. In some instances, may not be enough in other instances. So if therefore it is not enough in other instances, justification will be placed. A request for extension will be made to the affected parties. So it's not like it's an open-ended, as the business rescue was never designed that it should take longer. The legislators, they made it a point that they must state the time frame so that people appreciate the urgency of this matter. So that is why the anticipated timeline, whether it is correct or not, was that the business rescue proceedings must be completed within 3 months. And if not, then there must be then reports that are stating why it's not completed and what is need to be done and reported accordingly. So I can't say it is enough. I can't say it is not enough. It depends on the circumstances. If you come to a company and when you do your assessment, you find out that there's somebody who is not paying, and if this person, this data, we can get a person who can collect what is due to the company, I don't think that it would need 25 days. We just focus on that. So it depends on the circumstances which led to the company to be in financial distress. Will the BRP tariffs be increased in line with inflation? CIPC is the implementer of the Companies Act, and it's not a policymaker. All our policies are made by the department, which is the DTIC. However, we meet as a business rescuing committee comprising of professional bodies, where we raise some of the issues, and we know that the DTIC is looking in terms of some of the amendments, and they update us. At the moment when we last met, there were no movements in terms of the increase, in terms of the tariffs. But like any other policy, I believe that if people, they petition and they justify why they need these things to be reviewed, the department will look in terms of that and respond accordingly. Good morning. Is there a possibility of selling a company in business rescue to an investor? If yes, what is the procedure? Yeah, so if part of the plan is then to sell the company as a going concern, that will be part of the plan which should be approved, and therefore then the process will be followed in terms of selling and all those things by the parties that are involved in the transaction. It's not something that the CIPC or the Act will say this is how you do it. Then it will be a contract between the two parties, and then they will decide then in terms of how the contract should unfold. Okay, and then the other one was just to look in terms of the presentation. It says they seem the same. I think the colleagues will assist in terms of that. Colleagues, just look at Wendell Buke comment there. Do the directors of BRP have the authority to institute legal actions for recovery of monies for the company placed under business rescue? Yeah, so anything that has to do with the proceedings, the BRP has the authority to do that. And if the directors they want to do anything, they must do it under the authority of the PRP. Yeah, so they will have that if they know that they must recover funds. It's very important to recover monies for the company to come back. So they may then approach the appropriate court to do that. Is the determination for, I'm not sure for what, during the business proceedings not dependent on the depth of the whole? I'm not sure is the determination of what. If you may write again, Mr. Mauto. Is the duration, so you want to say is the determination of the duration, is the determination for the duration of the business proceedings not dependent on the depth of the whole? No. Section 132 is clear. The duration is 3 months. It's clear. It does not say if it is a if the threshold is this, it will be that. The standard is 3 months. And then when you deviate, then you must then explain. So the duration is 3 months. If then you have not met 3 months, then you must explain. Meaning that if you have gone beyond 3 months, then you must justify why. So the duration is there, it's prescribed. Does a BRP plan need to be adopted by creditors when the company appoints a new BRP? The previous one was removed due to fraud. Yeah, so the business rescue regime, it's an activism kind of a system where the affected parties they determine the path which must be then traversed. Now, when a plan has been approved and a practitioner is removed for fraud, it might not necessarily mean that the plan is wrong because of the person who was driving the plane has been now removed because of fraud. The creditors would want to continue with the plan, and if they want to change the plan, then they will have to discuss that with the BRP, and the parties then will agree in terms of that. So it does not necessarily mean that when the BRP is found guilty, then automatically the plan changes. So it's not like when it comes to political parties, if there's a change in a political party, then the policy will change because of the policies that are not the same. The business rescue plan is approved by the creditors, and the creditors will remain the same people. And if they see that the plan is going to achieve that which they want, they will continue with that. What recourse a BRP has when he calls for a creditors meeting and the creditors do not come forward, and when the BRP give the creditors to rather suggest the date of the meeting, the discussion of the plan, only a single creditor suggests the date and others do not, and they do not present themselves to the meeting. What must the BRP do in such? The same creditor who do not present themselves in the meeting but they complain to say PC. All right. So the reason the companies will go for business rescue, one is to make it a point that the company comes back to life. Number two is to ensure that the creditors are paid what is due to them based on the approved plan. And if there is no plan yet, but it means that what the BRP is trying to do is to ensure that we balance the interest of all the parties involved. So if a person who happens to be a creditor is not interested to be paid, it's mind-boggling. But all that I can say is that the BRP is an officer of the court, can approach the court and therefore make the necessary prayers, and the court then will decide on what to do. But no one is supposed to derail the proceedings, and therefore the business rescue practitioner can go to court and request the court to proceed with or without, if it is in the interest of the parties involved. I'm of the opinion that the attorneys and the magistrate do not understand what business rescue is. I was involved in the case where magistrate, set aside and approve the liquidation application by a creditor. Yeah, I can't respond on that. Yeah, I take your it's your opinion, and I think it has to be tested. I don't have the facts of the case and what makes you to believe that they did not understand. And I think matters such as this, if you feel that the matter was not dealt with appropriately and you want to appeal, and then you can follow that process. My father had a company and I want to register on my name. How do I do it? Okay, this is totally different. It's not business rescue, it's company registration. Please visit our website, Moses, www.cipc.co.za, and then you go to new registration. You'll get all the information there on registering a company. Okay, there are 2 new questions. So apart from the awareness and education program, what is the CIPC doing to promote and advance transformation within the BRP? Uptake and developments. There are many BRPs in the list, hardly receive assignments. Okay, now what CIPC does is to license business rescue practitioners. And in licensing business rescue practitioners, CIPC license practitioners across the board. So CIPC does not discriminate in terms of race, color, or gender. We license everyone. Number 2 is that CIPC engages the professional bodies to encourage them to come up with programs that will assist in ensuring that we try to redress the imbalances of the past and come up with the transformative agendas. I know one professional body, they have programs in terms of assisting where practitioners, they would work together, a program of mentorship. One area that also we are looking into is to engage the policy unit in terms of the actual definition of active engagement when it looks in terms of the experience when it comes to business rescue, because that says a person needs to be actively engaged as a business rescue practitioner in terms of this act. And if you are to look now, business rescue practitioner in terms of the act, it means a person who is licensed and appointed. And some people, they are not appointed, they are assisting the appointed practitioner. So these are the things that we are busy with as CIPC. But again, we are trying to make it a point that we engage the stakeholders to make use of junior practitioners in the event that the business is small, does not need an experience or senior. But we cannot dictate. We just encourage But when the chips are down, people they tend to go for what they believe that will assist them. So some companies, even if they are small, would want to make use of a senior practitioner, so that to them, I think it brings some comfort that the company may be restored. So these are the things that we are grappling with, but there's nothing that CIPC can do to force companies to appoint junior practitioners or to appoint this specific type of a person. Also, it's a responsibility of people that are doing the work to make it a point that they upskill themselves, they get experience, they do the work. For an example, they can even do um, informal rescues, advise to people to do informal rescues. Like in any industry, you can't force that these should be the people that are taken. So that's the unfortunate part. Should we cite CIPC on business rescue partners that go to court? Um, it, it it depends. It depends. If for an example, your prayer is that CIPC must do a certain thing, you can cite us, and CIPC would look in what is expected from them, because we, in most instances, we play a role which is impartial. So we tend to accept whatever decision that the court arrives at. So it depends. Um, and then the last one, maybe CIPC will file a notice to abide or provide legislative applicability information to court as a body charged with implementing the Companies Act and the regulations. Yeah. So I think here I think this is a follow up to the previous question. Yes. We just as I've said, in most instances, abide by the decision of the court. We normally don't have any interest in the matter. In fact, CIPC is not recognized as an affected party because we do not have any interest in this thing. Our focus is to ensure that we regulate the BRPs and manage the business rescue process. Thanks. Mr.
Thank you. Yeah, thank you very
Thank you.
much.
Thank you so much.
Thank you very much, Mr. Buyanin Kosha, for your wisdom and very well informed responses to the questions raised by our members to ensure that we add value. I believe so much that really you have done justice to the questions. However, I also like to express our sincere gratitude to the participants of this webinar for this fruitful engagement. And I think SCIPC, as the commissioner always say, it's about the continuous improvement. Whatever you've raised as CIPC, we normally use it to see to it that in our next coming webinars, which we will invite, obviously, again, look forward to that. We'll make sure that we we make improvements in this regard and engage more. And as Mr. Nkutla indicated, matters that require perhaps the TIC, we escalate to relevant forums to ensure that we give you uh, information as per your request. I therefore would like to say thank you and close this session. And please look forward to more of these webinars. And we would really appreciate your feedback in terms of how we can improve in this area going forward. Thank you and have a beautiful day. Thank you.